Okay. Standing by. I can hear you, Joe. Can you hear me? Okay, great. Thanks, Joe. Good morning, Joanne. Well, indeed, we are set to resume with the second phase of the public hearings at the Armsdale Commission. But let me tell you where we are right now. We are inside the chamber here at the Semi-Marks Conference Center where these hearings have been held. All the legal teams, really pretty much everyone who should be represented, well, almost everyone who should be represented is here. The lawyers from the Department of Defense and also the lawyers for human rights, some of the Armsdale critics, lawyers are already here and evidence leaders already here. But the one thing missing is really the witness, witness Richard Young of C squared, I squared. You'll remember that on Friday, just at the end of the proceedings, Judge Seriti, wanting to get clarity on whether the witness had been issued with a subpoena after it was pointed out by evidence leaders that the witness seemed to have some issues with the commission, issues that were not really outlined. Now, this presents a number of interesting permutations here, Joanne, because indeed it was confirmed that Richard Young has been subpoenaed, and if he is not here, we're not sure at this stage what is happening, but we do seem to be having some kind of a delay, and the witness, we can confirm, is not here yet, and it would present interesting possibilities if indeed he were to end up not coming to the commission.
Good morning, everybody. Advocate Skinner.
Good morning, Chair and Commissioner Musi. It was anticipated that the first witness at the commencement of phase 2 of the hearings would be Dr. Richard Young. Unfortunately, Dr. Young is not present today, and it is perhaps necessary for me to give some background to that statement. At a recent consultation with Dr. Young, I specifically asked him whether he was willing to give evidence, and his response was that he was indeed willing to give evidence provided he was properly prepared and able to do so. Originally, it had been planned by all the evidence leaders that he would be the last witness in phase 2 of the hearings. Approximately a month ago, in mid-June of this year, the Commission came to the view that it would be better for various reasons that he should be the first witness in phase 2. This necessitated urgent consultations being held because the last consultation that we as evidence leaders had held with Dr. Young had been over a year ago prior to the start of phase 1 of the hearings. Unfortunately, this need for urgent consultations coincided with personal circumstances of Dr. Young in the sense that he had to undergo an operation to one of his eyes. In that regard, attorneys representing him have submitted 2 letters to the Commission. Chair, I'm not sure that it's necessary to read the entire letters unless the Chair wishes me to do so.
Advocate Skinner, read the entire contents of those letters into the record.
Certainly, Mr. Chair. The first letter is dated 17 July 2014 from attorneys Bernard, Vukic, Potash and Getz in Cape Town, and it commences, "We act on behalf of Dr. Richard Young and C2I2 Pty Limited. We address this correspondence to you on behalf of Dr. Richard Young, our client. Our client has instructed us that he has been provided with a summons in terms of Section 3(1) of the Commissions Act 8 of 1947, in which he was called upon to attend the Arms Procurement Commission of Inquiry on 21 July 2014. This summons was served on our client's secretary at the C2I2 offices in Kenilworth. The purpose of this letter is to explain why our client will not be attending the Commission on 21 July 2014. Our client has instructed us that the Commission has previously accepted written submissions without the presence of parties or legal representatives being present. We request that the Commission accept this letter as our client's submissions. Our client has not instructed any legal representative to attend the Commission for that reason, as he does not wish to do so at considerable expense to him. Our client underwent a corneal transplant operation 3 weeks ago, which resulted in him being off work for a period of 2 weeks as his vision was adversely affected. He subsequently suffered a fungal infection which caused the healing of his eye to be delayed, and his vision has been very limited as a result. This has caused our client difficulties in preparation, as he cannot read documents, be they hard copies or electronic copies displayed on a computer screen, easily. And once he commences working, he can only do so for a relatively short period of time. Our client again consulted with his ophthalmic surgeon, Dr. Michael Attenborough, on 16 July 2014, who stated at that consultation that he would produce a doctor's note in which he will report on our client's condition. This will be provided to the Commission as soon as it becomes available from Dr. Attenborough. As a result, it will not be possible for our client to appear before the Commission to testify on 21 July 2014. It would in any event be an exercise in futility for our client to appear under those circumstances. At best, our client would testify for an hour or 2 before being unable to continue until the next day. Our client's vision is likely to improve or at least stabilize over time. However, he will require more time to prepare and give evidence due to this difficulty. On 11 July 2014, our client sent an email to the evidence leaders appointed by the Commission in which he requested details of the arrangements for him to travel from his place of residence to the offices of the Commission on 21 July 2014. He has yet to be provided with any details of travel arrangements. Our client cannot be expected to attend the Commission when no arrangements have been made for him to travel to Pretoria. For these reasons alone, our client cannot testify on 21 July 2014. There are, however, a number of other reasons why it is not possible for our client to testify on 21 July 2014. Our client has instructed us that, sub 1, the schedule for the witnesses to be called after 21 July 2014 is entirely unrealistic, and it would be impossible for the program to be completed. Our client has repeatedly stated that his evidence will take between 1 and 2 weeks without cross-examination. It would thus be impossible for our client's evidence to have been completed within the 3 days allocated. We understand that Ms. DeLille will testify on 24 July 2014, which date has been set in stone and cannot be moved. Sub 2, the evidence leaders of the Commission started preparing his evidence 2 weeks ago due to the change of the order of witnesses. The evidence leaders only requested our client's discovered documents 2 weeks ago from our client in electronic format. As a result, our client's evidence has not been adequately prepared in the circumstances due to no fault of the evidence leaders. Sub 3, the affidavit on which our client's evidence is to be based is over 3 years old. The draft witness statement produced by our client, which is to be the basis for a part of our client's evidence, is also hopelessly out of date as it is based on this affidavit. This will lead to confusion regarding his evidence. Our client has repeatedly stated that he was prepared to update his witness statement. No draft has yet been produced for or settled by our client. This should be done before his evidence commences. Sub 4, there are 1,061 documents which our client has discovered, and our client believes that some 200 documents, approximately 5,000 pages, would be relevant to his evidence. No bundle of documents has been produced or made available for our client to prepare his evidence. As a result, his evidence would be impossible to lead sensibly. It would result in long delays in which our client would have to search through masses of documents to locate a document or part of a document. Sub 5, much of our client's evidence is to deal with the evidence of Norkeer and Kamerman, whom our client was granted leave to cross-examine, but could not, as their witness statements were only made available to our client after their evidence was concluded. Our client thus would like to cross-examine Norkeer and Kamerman before he commences his evidence in chief. Sub 6, our client has been requesting specific documents in terms of the Commission's rules from Arms Corps and the Department of Defence, which our client believes are relevant to the Commission and which were referred to in other discovered documents. Our client's request for one particular document, which has been sought by our client since 2001 from the Department of Defence and 2013 from the Commission, has been ignored by the Commission. Our client requires this document as well as others in order to testify. Our client has repeatedly emailed the Commission and the evidence leaders to state that, sub 1, the date of 21 July 2014 was not suitable for medical reasons and due to the fact that his farm workers were taking leave. Sub 2, it was impossible for his evidence to be ready for the reasons set out above. Sub 3, the time allocated for our client's evidence was insufficient. Sub 4, his evidence requires weeks in order to prepare. Our client understands that a memorandum has been produced by the evidence leaders dealing with our client's unavailability to testify on 21 July 2014. The Commission has thus been aware of these difficulties for some time. Despite this, the Commission has refused to be accommodating to our client, although it has been accommodating in respect of other witnesses due to their circumstances. Furthermore, our client was required to produce a witness statement and to bring an application in order to cross-examine a witness before the evidence of a witness was led. Our client is not aware that any such application has been made regarding other parties cross-examining him. In order to properly lead his evidence, our client requires these matters to be resolved and dealt with in the same manner in which his applications were dealt with. It will be grossly prejudicial to the conduct of the Commission and our client should he be required to give evidence before the Commission in these circumstances. We point out that our client would like to testify at the Commission and believes that it is important that he does so. He would like to testify at a time when it would be possible for him to do so, and once he has had sufficient time for his evidence to be prepared. Our client would be happy to engage with the Commission in order to arrange a suitable time and will be cooperative in this regard. Mr. Chairman, that was then followed by a letter from Dr. Young's attorneys on the 18th of July 2014, which reads as follows. We refer to the email dated 18 July 2014 sent to us by Advocate Mdumbi at 13 hours 44 Central African Time. In that email, Advocate Mdumbi confirmed receipt of our email of 17 July 2014 and indicated that the issues raised in that email will be dealt with on 21 July 2014, presumably at the commencement of proceedings before the Commission. Advocate Mdumbi also requested that we furnish the Commission with a copy of our client's identity document in order to finalize his travel arrangements to Pretoria. This email is puzzling as it appears to ignore the reasons given on behalf of our client explaining why he would not attend the hearing of the Commission on 21 July 2014. It is also strange that the Commission would wait until Friday afternoon to make travel arrangements when it was indicated that it should do so by our client a week earlier. This is clearly unacceptable. What is more disturbing is that the Chairman of the Commission is reported to have stated at approximately 14 hours 26 Central African Time on 18 July 2014, after the conclusion of former President Mbeki's evidence, that our client has been served with a subpoena and that he expects our client to attend on Monday whatever our client's issues. This, of course, contradicts the email from Advocate Mdumbi sent to us at 13 hours 44 Central African Time today, in which he stated that the issues raised in our letter would be dealt with on 21 July 2014. From this statement by the Chairman, it appears that, sub 1, the Chairman of the Commission had knowledge of our letter dated 17 July 2014. Sub 2, the Chairman has reached a decision regarding our client's submissions as contained in the letter. And sub 3, notwithstanding those submissions, the Chairman of the Commission expects our client to attend the Commission. This is significant in that we had indicated that our client would make available a note from his ophthalmic surgeon, Dr. Attenborough, dealing with his medical condition. The Chairman made a decision without calling for this document, which indicates that he did not apply his mind to the contents of our letter before making the decision, or he regarded it as irrelevant in reaching his decision. In either event, the decision is, with respect, not rational or procedurally fair. It would now be pointless for our client to cause a legal representative to appear and make submissions on his behalf on 21 July 2014, as a decision has been made. Our client has advised us that Dr. Attenborough has been in surgery and consultations yesterday and today, and for that reason has been unable to provide our client with a note referred to in our previous letter. This note may only become available over the weekend or on Monday morning. It will be provided to the Commission as soon as possible. Our client will not be attending the Commission on 21 July 2014. Our client respects the Commission and the purpose for which it has been established. He repeats that he would like to testify at a time when it would be possible for him to do so properly. Mr. Chairman, that was then followed by a note from Dr. Attenborough forwarded to the Commission by Dr. Young's attorneys shortly before the commencement this morning. It is dated today's date of 21 July 2014 and reads as follows. Dr. Young had a corneal transplant in his right eye on the 26th of June 2014. He had a severe fungal infection in the eye prior to his surgery, which has resulted in slow visual recovery on that side. This has caused him to have unbalanced vision, which makes reading tasks difficult and gives him headaches. He requires at least 6 weeks after surgery for this to settle, but will only be able to read for short periods of time for the next 2 to 3 months. If you require any further information, please do not hesitate to contact me. Mr. Chairman, the result is that, unfortunately, we are in the situation that Dr. Young, for the reasons advanced, is not present, and we as evidence leaders are not able to say to the Commission that even if he was present, we would be able to lead his evidence. As was mentioned in the first letter from his attorneys, we had canvassed with him the possibility of leading his evidence based on the commission he had deposed to the Constitutional Court and the draft statement that he had submitted to the Commission at an earlier stage. Dr. Young's response was that circumstances had changed considerably from the time that he deposed to that affidavit some years ago, in the sense that he has had access to and located other documents and has obtained more information which is not dealt with in his affidavit. And that secondly, the draft statement was prepared by him for purposes of cross-examining the witness, Mr. Fritz Norkier, and that it was not complete by any means. He made it very clear that he felt it would be extremely unfair to him, in the light of the fact that it is anticipated he will be subjected to intense cross-examination, if he is compelled to give evidence at a time when he is not ready to do so because of the problems inter alia with his eyesight. As evidence leaders, we have to agree that he is not ready to give his evidence at the moment. One illustration of that is that we simply cannot prepare bundles of documents for him until we have an exhaustive list of all the documents that he intends to refer to in his evidence. In these circumstances, we reluctantly have to suggest to the Commission that his evidence should be held over until a further date for his evidence can be arranged. As indicated in his attorney's letter and read with the note from his surgeon, the anticipation is that the earliest that would be round about the first week of October.
Thank you, Advocate Skinner. Am I right to say, according to the letters that we have received from Dr. Richard Young's attorneys, there's another 1,000 or 2,000 documents that he said that needs to be gone through before his evidence can be prepared, his statement can be prepared?
Yes, Mr. Chairman, the position is, as we understand it, that there was a meeting held in March of this year, attended by representatives from the Commission as well as the legal representatives of Arms Corps and the Department of Defense. At that meeting, Dr. Young made available a disk containing in electronic format the 1,061 documents that he refers to, which he has informed us amount to some 20,000 pages. As referred to in his attorney's letter, he believes that of those documents, approximately 200, being some 5,000 pages, would be relevant to his evidence. Now that would be necessary for us as evidence leaders to take him through to establish are they indeed necessary before we are able to say they should be furnished in the form of bundles to the Commission.
Thank you. Although I've got my own views about that, we have gone through so many documents in order to prepare Dr. Young's evidence. Now to go through another 21,000 documents which we're not even sure whether they're relevant to this inquiry, I think is an issue that we need to look at a later stage. Advocate Mdume, maybe just before I ask you to comment on behalf of the Commission, let me finally return Advocate Kane. wants to say something before we wrap up this issue.
Thank you, Chairperson. There are a couple of aspects that directly impact on the Department of Defence, so I do value this opportunity. The first pertains to Dr. Young's allegation in paragraph 8.6 of his letter of 17 July 2014 that he has been requesting specific documents in terms of the Commission's rules from Arms Corps and the Department of Defence. You may recall, learned Commissioners, that during March 2014, you determined applications brought by Dr. Young in relation to the discovery of documents. You heard the applications and they were dismissed. The Department of Defence has not been made aware of any further requests for specific documents from Dr. Young since then. And the state of the matter in relation to those papers was that Dr. Young had requested the Naval Board minutes from the Department of Defence, and it had become common cause that they had been provided. The upshot being that at the end of that discovery procedure, the Department of Defence was not aware of any further requests for specific documents from Dr. Young, and as far as we are aware, none further have been made. Insofar as Dr. Young does still require specific documents from the Department of Defence, therefore, he is requested to please specify what is outstanding so that that may be dealt with. There is certainly no intention on the Department of Defence side to withhold documents from him or to cause delay because they haven't been provided. So we would like to actually attend to that issue. The other matter is Dr. Young in paragraph 8.5 of the same letter has now alleged that he would like to cross-examine Nokia and Kammerman before he commences his evidence in chief. There are two aspects there that are confusing to us and require clarification. The first is that on the record he has withdrawn his application to cross-examine Mr. Nokia. And as far as we are aware, there's no further application to cross-examine Mr. Nokia. There is an application to cross-examine Mr. Kammerman. And that we're well aware of and have tendered, and Admiral Kammerman has tendered to return for those purposes. The concern is whether that necessarily should be before Dr. Young commences his evidence in chief. As you know, Commissioners, the directives, in particular paragraph 3 of the directives, provide that the conduct of and the procedure of this inquiry shall be under the control and discretion of the chairperson. Now, unlike in adversarial litigation where the party commencing has to discharge an onus and so leads evidence and is cross-examined on that evidence and closes their case prior to the defendant being even called to lead evidence in chief, this is an inquiry where there is no reason in policy why you should not direct which order the evidence progresses in, and I can think of no reason in policy why it should necessarily be so that Dr. Young should make it a precondition that he be given the opportunity to cross-examine Admiral Kammerman before he commences his evidence in chief. That is a matter entirely within your discretion. The Department of Defence has no particular preference as to which procedure runs first, only stresses that this should not be used by Dr. Young as a manner to control this commission or dictate its terms. We will cooperate with whatever the commission determines as being convenient for the leading of evidence. Thank you.
Advocate Ndume, some few things I think you need to comment to because Dr. Young was dealing directly with you with correspondence.
Yes, Chairperson and Commissioner Mosi. we deem it imperative as the Commission to respond to some of the to the following averments which are contained in the letter of the 17th of July 2014 from Dr. Young's attorneys. They state that A, on 11 July 2014, Dr. Young sent an email to the evidence leaders in which he requested details of the arrangements made for him to travel to Pretoria to attend the Commission sitting of the 21st of July 2014. To this request, he says he received no response. B, that the schedule for the witnesses to be called is entirely unrealistic and it would be impossible for the program to be completed. C, the evidence leader started preparing his evidence 2 weeks ago due to the change of the order of witnesses. D, Dr. Young has produced 1,061 documents, 200 of which he believes would be relevant to his evidence. E, that Dr. Young intends cross-examining Mr. Fritz Norkia and Admiral Kammerman before he commences his evidence in chief. F, that his request for documents from Arms Corps and the Department of Defense have gone unheeded. Chairperson, to these assertions, we do intend to respond, and I do so now. Dr. Young alleges that he inquired from both Advocate Skinner and Sibia about his travel arrangements and received no response. This inquiry was never brought to the attention of the Commission. On Friday, 11 July 2014, the Commission sent an email to Dr. Young advising him that his evidence set down for hearing on the 21st of July 2014 had not been deferred, and requesting him to indicate preferred date and time of travel to Pretoria to attend the Commission sitting of 21st July 2014. To this request, Dr. Young responded by saying, and I quote, "It is the responsibility of the Arms Procurement Commission as a consequence of issuing summons to make all provisions and arrangements in respect of travel from residence to destination and return, as well as subsistence during the relevant period. There is nothing that I have to do in this regard," unquote. The Commission neither directed nor received further queries in this regard from Dr. Young. On 17 July 2014, it requested Dr. Young's identity number for the purpose of finalizing his travel arrangements, which he graciously provided. The Commission finalized his bookings and forwarded his e-ticket, hotel and shuttle vouchers to Dr. Young on Friday evening at around 7 p.m. Dr. Young says that the schedule is unrealistic and insufficient time has been allocated to his evidence in chief. The dates allocated by the Commission to witnesses, either for the evidence in chief and or cross-examination of witnesses, are not cast in stone. If the Commission consulted each and every witness and their legal representatives before it finalizes its witness schedule, its work would grind to a halt. The ultimate decision in connection with these issues rests with the chairperson of the Commission. This is implied in paragraph 3 of the directives issued by the chairperson, which were published in the Government Gazette number 35325 of 9 May 2012, which states, The conduct of and the procedure of this inquiry shall be under the control and discretion of the chairperson. Dr. Young states that evidence leader started recently to prepare his evidence. It will be recalled, Chairperson and Commissioner Musi, that Dr. Young was among the critical witnesses who were earmarked to give evidence in March 2013. Even before a subpoena, which required him to appear before the Commission on the 25th of March 2013, was served on him, the Commission's evidence leaders, namely Advocate Skinner, SC, Advocate Libala, SC, Advocate Sibiya, and Advocate Ngobese, consulted with Dr. Young in his offices in Cape Town on the 20th and 21st of February 2013. Furthermore, in the absence of a formal submission to the Commission by Dr. Young, and to ensure that the evidence leaders were au fait with the issues pertaining to Dr. Young and his company C-Square I-Square, the Commission collated documents, including Dr. Young's affidavit and annexures, which is submitted to the Constitutional Court in support of Mr. Terry Crawford Brown's application in case number CCT 103/10, his settlement agreement, C-Square I-Square best and final offer for the NEF distribution subsystem and the information management subsystem for the combat suite. Formal complaint to the police by Dr. Young dated October 2009. The record of the Western Cape High Court in a matter between Dr. Young and Eunice Sheikh. The record of the High Court in the matter between C-Square I-Square and the Minister of Defense, Arms Corps, and the African Defense System, case number 217/02. The record of the High Court matter between Dr. Young and Selby Bakwa, case number 2161/2003, and other miscellaneous documents. The Commission's evidence leaders commenced sifting through these documents, which were contained in 10 Acliver files in March and June 2013. Consultations with Dr. Young never stopped. Advocate Skinner and Advocate Sibiya met again with Dr. Young in Cape Town on the 4th and 5th of June 2013. At this time, they also commenced working on Dr. Young's draft statement. It is important to mention this because when these consultations took place with Dr. Young, they happened at the time when the Commission had decided that it would call officials and members of the Interministerial Committee to come and give evidence before it, and not the critical witnesses. Advocate Skinner and Sibiya consulted with Dr. Young again recently on the 8th, 9th, and 10th of July 2014, and again on the 16th, 17th, and 18th of July 2014. As far as I am aware, Chairperson and Commissioner Musi, no other witness has been consulted with as extensively as the team has done with Dr. Young, and maybe I should add, at a huge cost to this Commission. Dr. Young says that he would need to cross-examine Mr. Norkia and Admiral Kammerman, and he requests documents. Dr. Young submitted an application to cross-examine Mr. Norkia on the 17th of October 2013. On the 25th of October, the Commission informed Dr. Young that his application to cross-examine Mr. Norkia has been granted and drew his attention to the fact that he would commence giving evidence on the 4th of November 2013. To prepare, he requested to be provided in advance with copies of Mr. Norkia's bundle. This request was complied with. On the 29th of October 2013, Mr. Norkia's bundle was delivered at Dr. Young's offices in Cape Town. On the 3rd of November 2013, Dr. Young withdrew his application and replaced it with a new substantive application. He attached Appendix A to this application, setting out the documents he required. Among them, the supply contract for the Aerospatial Exocet MM40 surface-to-surface missile, concluded between Armscor and EADS in 2000, the umbrella agreement for the Patrol Corvette Combat Suite, and the transcripts of Section 28 interviews. Chairperson, I think it is important that we mention that the Commission only received authorization or approval from the National Director of Public Prosecutions in June to distribute the Section 28 interviews. And we have received recently the redacted versions of the umbrella agreements and all the attachments thereto. In an email dated 19 November 2013, Dr. Young submitted further requests for documents. Among the documents required were the following: transcripts of Section 28 interview of Mr. Sheikh, the report of the Texas Diacerto database, and the report of the IMS and Texas Diacerto database from Fritz Norkier to Sipotom. On the heels of this request came another request on the 22nd of November 2013, in which Dr. Young requested all documents used in the JIT interviews of certain individuals whose names he specified. On the 19th of January 2014, under cover of an email, he requested all reports, memoranda, documentation, Patrol Corvette JIT correspondence, Armed Corps correspondence, DOD correspondence, Siemens correspondence concerning South African Cable Manufacturing Company, Bartel Kalbel Werke, dated between 1997 and 2004. On 10 January 2014, Dr. Young submitted a formal application to be furnished with the copies of the witness bundles of Captain Yuri Jordan, David Chrysel, Beryl Smith, and Fritz Norkier. In the aforesaid application, he mentioned that he stated that he advised the Commission on 8 January 2014 that he wished to cross-examine Admiral Jonathan Kammerman. He further requested a list of all other documents held by the Commission that are relevant to the covert component of the SDPP. On the 24th and 25th of February 2014, Dr. Young submitted applications in terms of Rule 35 of the Uniform Rules of the High Court to be furnished with the relevant documents. On the 27th of February 2014, Dr. Young withdrew his application to cross-examine Fritz Norkier. This has had an impact on the Commission processes. On 6 November 2013, the Commission stood down the evidence of Mr. Norkier to give Advocate Libala, SC, who had been assigned to lead the evidence of Mr. Norkier, the opportunity to consult with Mr. Norkier, to deal with the documents which Dr. Young indicated to this Commission that they'd be relevant to the evidence of Mr. Norkier. The chairperson further issued a directive that those who intend cross-examining a witness must be ready to proceed immediately after the witness has given evidence. On the 5th of February 2014, the legal representatives of Armscor informed the Commission that they were wary to allow Mr. Norkier to take the stand before he had seen the documents in the possession of Dr. Young, nor gone through the documents Dr. Young wished to rely upon. The inordinately long time that passed without Mr. Norkia having given his testimony, was captured by the chairperson in the following terms. Mr. Norkia, I quote Chairperson and Commissioner Musi, Mr. Norkia was supposed to have testified in November 2013. We are now 4 months down the line, and I don't think I'm going to allow a situation where we are going to delay the testimony of Mr. Norkia, unquote. On the 3rd of March 2014, the Commission's evidence leaders requested the Commission to grant them leave to meet with Dr. Young to discuss issues pertaining to the evidence of Mr. Norkia. To this request, the chairperson responded, and I quote, "We should have dealt with the evidence of Mr. Norkia last year, November, which we did not because you wanted to accommodate Dr. Young. It is now almost 4 months down the line. We are still having the same problem. The lifespan of this commission is only 9 months. We are left with 9 months. For how long are we going to try to accommodate Dr. Young before we can call Mr. Norkia? If we are going to spend another 4 or 5 months talking to Dr. Young before we can call Mr. Norkia, we'll never finish our work. That is my difficulty," unquote. The Commission suspended the order compelling Dr. Young to discover documents by 3 March 2014 and his 2 applications wherein he intended compelling the Commission, Arms Corps and the Department of Defense to discover documents until the 17th of March 2014. Commissioner Musi commented during the proceedings, I quote, "I think what we are doing, we are trying to bend over backwards in order to accommodate Dr. Young. He has proposed that he can withdraw his application to cross-examine the witness, and we don't think it will be wise that he should be allowed to do that. I agree with the sentiments of the legal representatives that we should try and keep him on board," unquote. On the 24th of March 2014, it was pointed out that Dr. Young withdrew his application to cross-examine Mr. Norkia, and that if he wished to cross-examine, he would be required to bring a new application to recall Mr. Norkia, which application would have its own requirements, and only then would the applications for discovery become relevant. The Commission ruled as follows, I quote, "We have now looked at the applications and listened to arguments presented before us by counsel and are of the view that Mr. Young has not made a case for any of the orders he is seeking before this Commission. And 3, the Commission cannot grant such a broadly worded request for access to documents, because if we do that, then we will create serious difficulties for both the Commission and the DOD, and therefore the applications by Dr. Young against the APC, DOD, and other parties are therefore rejected." Dr. Young withdrew his application to cross-examine Mr. Norkia. He is yet to submit an application to cross-examine Admiral Kammerman. His applications for orders compelling Arms Corps and the Department of Defense to produce documents were dismissed by the Commission. Chairperson, in the light of everything that has been happening between us and Dr. Young, I would like to conclude by saying, perhaps stating the obvious. Dr. Young has participated as a witness at the JIT, and he is not a total stranger who still has to amass information regarding specific allegations he has on the matters pertaining to the arms procurement. Chairperson, it is a simple principle of law that he who alleges must prove. However, Dr. Young persistently seeks information from the Commission as if he has not previously made allegations in court, papers, in the print and electronic media. All that is needed from him by this Commission is to repeat such allegations formally here in public. I thank you, Chairperson. Commissioner Musi.
Thank you. I think it's unfortunate that Dr. Young was unable to be here today. We had hoped that he will be in a position to testify about issues that are within his knowledge, particularly dealing with the alleged corruption that took place in this procurement. Unfortunately, he's not here. And two, I think we're going to defer our position as far as Dr. Young is concerned. We have tried to bend backwards to accommodate Dr. Young, and up to now we have not yet succeeded to get him to give us a statement that he's going to use in this commission, if ever he'll ever testify. And for that reason, we're not going to make any order whatsoever about his next appearance. We're going to sit back, look at other evidence, review our position, and from there make a decision on whether we still require Dr. Young to testify or not. So we are going to adjourn, and we'll only be back on the 24th. The question of Dr. Young, I think we'll deal with it at a later stage. At this moment, we're not going to make any order. And I think, if I recall, our next sitting is on the 24th. And Advocate Lubala is the one who's supposed to lead Mrs. Delil. Is my information correct?
Chair, I think of no one better qualified to assist at this stage than Advocate Mudumbe. Certainly, we envisage leading the evidence of Ms. Delil on the 24th on Thursday with some difficulties and realities. I would like to give over to Advocate Mudumbe, not as pronounced as those of Dr. Young.
Yeah, Advocate Lubala, what I was interested in is that Mrs. Delil has been subpoenaed. He's supposed to come on the 24th. You have consulted with her. Is she going to lead the evidence on the 24th?
Let me give over to Advocate Mudumbe first.
Okay.
Chairperson, Commissioner Musi. Yes, Ms. Delil will be here on the 24th.
Thank you. That's all that we need to know.
Yes.
She will be here to testify on the 24th. Thank you. We're going to adjourn until the 24th, and we'll start at the usual time, which is 10 a.m. Thank you. We're now adjourned.